All right, welcome to the Chapter 12 video lecture. This chapter deals with documentary evidence and the right of discovery. So documents as a type of evidence. Documents are letters, words, numbers or their equivalent set down in any form. Frequently, documents are classified as either public or private. Public documents are laws, judicial records, driver's licenses, marriage applications, records of deeds, mortgages. Private documents are letters, memoranda, answering machine message, a suicide note, an email, a text message, or a will. So it's distinction between public and private as far as documentary evidence goes. Authentication and the best evidence rule. Authentication is the foundational requirement that the authorship or genuineness be established. The best evidence rule requires that when someone seeks to prove the content of a writing, recording, photograph, the original must be presented unless there's a good reason why the original cannot be presented. So these two things work hand in hand. When you want to bring in maybe a photograph as an exhibit, you need to authenticate it, that this is a genuine photograph of the crime scene or the victim. And then you also need to establish that this is the original as part of the best evidence rule, or you need to establish why it's acceptable to use a copy of the original in this circumstance. So looking a little more at authentication, this is just a prerequisite to show, and it requires the party who wants to use the evidence introduce it and just verify that it is what you claim it to be. There are an unlimited number of ways to authenticate something under the federal rules of evidence. So the party who wants to introduce the photograph demonstrates that it's relevant. So if it's of the crime scene, that's a relevant issue. They lay the foundation for the photograph by having the person who maybe took the photograph come in and say, I was at the crime scene, I was called there, I took photographs. This is a photograph I took of the crime scene that day, that time, and I have done nothing to it since then. This is an original, ideally, to satisfy that best evidence rule. When you're dealing with a document, the original needs to be established, and it needs to be genuine. So again, these things are working hand in hand. The Federal Rules of Evidence 1003 allows a duplicate to be admitted into evidence to the same extent as an original, unless it's unfair or there is a question to its authenticity. Under the Federal Rules of Evidence, a duplicate is a copy produced by methods possessing an accuracy with which virtually eliminate the possibility of errors. So something like a photocopy. Copies that are handwritten or typed are not a duplicate. The best evidence rule does not apply to like witness testimony or tangible evidence. It only applies to writings, recordings, and photographs. So just make sure we don't take this concept and apply it elsewhere. It's limited to this one spot. So satisfying the rule, if, for instance, a copy was taken of that photograph of the crime scene, that is a duplicate. It's going to be admitted. Faxes are also going to be a copy. A duplicate of a recording would be any counterpart produced from the same matrix as an original means of mechanical or electronic recording. The negative and any print constitute the original. Therefore, most means of producing a dupe of another photograph would be a duplicate that would satisfy. So if the crime scene photographs got destroyed, they could go back and pull out the negative or the chip or whatever, however it's being stored, and print more, and those would be a duplicate, and that would be perfectly acceptable. Now, for a document, when that is produced in court, that is primary evidence of what that document contains. when other evidence is substituted for that document, the substituted evidence is called secondary evidence because it is not the original. And the most common form of secondary evidence of a document is testimony of a witness. So if the original cannot be produced and a duplicate cannot be made, a witness can be called to testify to the content of the writing, the recording of the writing, and that is going to be secondary evidence. So the times where secondary evidence is used are when the original was lost or destroyed, it's unobtainable by subpoena, it's in the possession of an adverse party and the adverse party refuses to produce it, it's in the custody of a public officer, it's a collateral matter, or it is voluminous and it cannot be examined without a great loss of time. So making a summary is more, would be sufficient. So when you need to produce secondary evidence of the document or the photograph or the recording, you need to demonstrate that a writing was in existence, the secondary evidence is a genuine copy or accurately reflects in the reason why the secondary evidence is being offered instead of the original. When a party alleges that the original was lost, there needs to be a showing that you looked really hard to find it. How hard will depend on the kind of document and how important it is to the case. If it is a key part of the case, you're going to have to look a lot harder than if it's a collateral or secondary, like side matter. When the criminal defendant holds the document, the notice to produce will be given to them, and that has to be established that you gave them a notice to produce and they refused to comply before you can offer secondary evidence to the court. Notices to produce they don't have to be standardized. It is just a better way to be formal though, even though an oral request would suffice, it's just not the best practice. If a document is essential, a subpoena d'ostempé will be issued to order someone to bring specific evidence. So if medical records are necessary, a subpoena could be issued for the medical records to give, to a hospital that treated the patient, that those documents be produced at trial. Now, the Fifth Amendment still applies to the production of evidence. So if a document would incriminate the defendant, they can withhold the document. If it's a collateral matter, in other words, just incidentally or tangentially related to the issue, secondary evidence can generally be used. All right, moving along. When the document is in the custody of a public officer, the federal rules expressly exempt public records from the best evidence rule. So that's just a complete exemption. Certified documents are authentication of a copy does not require additional evidence if a statement by the person, official, or clerk having custody of the record certifies that the document is a true copy of the original and attached is a true copy. So this is a certified copy. This would definitely be admissible. An exemplified copy is in a criminal case where the prosecutor is looking to establish that the accused was convicted of a crime in another state or another court proceeding. The record of conviction must be certified by the clerk of the court, as well as by the presiding judge of the jurisdiction, attesting that the clerk correctly filled out the certified form. Again, this is just making sure the defendant's rights are protected. If it's really voluminous, if it's really large, it can be challenging to get the best evidence, and if it is, copying and examining the original at a reasonable place and time is an acceptable alternative. Original document is the document itself or any counterpart intended to have the same effect by the person who executed or issued it. So if you signed multiple copies of the same one, intending them to be the same, that's kind of what this is getting at here. Inscribed chattel are objects with words and or images painted or engraved on it. So this might be a truck with a business logo, a police officer's badge. These types of items, inscribed chattel, are not subject to the best evidence rule. This makes sense, right? They are not documents, photographs, or recordings. They are chattel. But the judge can have considerable discretion and maybe allowing a photograph of the logo to be admitted into evidence instead of, the actual logo on the side of the vehicle. Again, judge will look at the need for precise information, the difficulty of producing, and simplicity or complexity. So and there are things that could be extremely relevant to a trial that cannot be reproduced in another way. But something like a logo, a photograph would often suffice. All right. Shifting gears a tiny bit here for the last bit of this. The right to discovery in a criminal case is the right given to your adversary to examine, inspect, or copy evidence in the hands of the other side. Fairness requires discovery to be reciprocal, but it cannot be completely reciprocal in a criminal case because the defendant has Fifth Amendment protections against self-incrimination as well as they're entitled to attorney-client privilege. So in discovery in criminal cases is intended to provide the defendant with enough information to plead and prepare for trial, avoid surprises to both sides, promote judicial economy, and speed up the trial process. Upon request, so the defendant has a burden to request this, defendant can obtain from the prosecution any statements or transcripts made by the defendant possessed in the prosecutor's hands, the defendant's prior criminal record, documents, photographs, tangible objects, results of physical, mental examinations, and test reports possessed by the prosecutor that the prosecutor intends to use as evidence in trial or the court deems material to the trial preparation. All right, moving along. Sorry, I know that you probably saw like a head pop in. I'm recording these from home and my kids are here. So exceptions to the right of discovery include the defendant cannot have the ability to discover the identity of a confidential informer unless it is vital to the defense. There is an obligation of the prosecutor to disclose exculpatory evidence under the Brady Rule, and the defendant's right to discover written or recorded statements of witnesses must be turned over in accordance with the Jinx Act in federal court, and there's similar state statutes. So those are some exceptions. Continuing on so this is expanding upon that Brady Rule in the last slide, Brady versus Maryland. There's a general prosecutorial duty to disclose exculpatory evidence to the defendant before trial. And what that means is evidence that tends to exonerate. So it doesn't have to be a smoking gun, but anything that makes it more plausible that the defendant is not guilty of this offense would exonerate. Discovery through preliminary hearing. The defendant needs to make a discovery request before trial. In many jurisdictions, though, before you can even have an opportunity to make the motion for discovery, prosecutors are presenting at least some evidence at a preliminary hearing. And again, the preliminary hearing is the stage where the judge determines whether probable cause exists to believe this defendant committed the crime. So the prosecutor here needs to present enough evidence to show the judge or magistrate that there is probable cause that this particular defendant committed this particular crime and to move the process forward for trial. It's called binding over. So preliminary hearing does give the defendant some notice as to what the prosecutor has, but a preliminary hearing is not guaranteed in every jurisdiction. particularly jurisdictions that prosecute through indictments instead of information. So indictments are usually coming from a grand jury instead of an information that's coming from the prosecutor's office. So again, just something to think about as we're working. All right, jumping ahead a few slides here. So matters that are generally included in discovery are statements of prosecution witnesses, names and addresses of informants, particularly when probable cause stems from that informant. So notes made by witnesses, documents, a notebook used by an officer, photographs of the defendant, and scientific reports. So again, just kind of reaffirming, photographs of the crime scene, any real evidence are all subject to discovery. And again, it's really important. The defendant, there's no provision in the federal law for defense to access witness information, but the state trends are moving the other way. And the last couple slides deal just a little bit with informers, and then we have a prosecutor's right to discovery. So the last couple slides deal with an access to a law enforcement officer's notes. But we covered through a lot of material here. If you have any questions, let me know. I definitely prioritize making sure understanding authentication and best evidence rule.